Welcome to Working for Women, the Independent Women's Forum podcast, where we are changing the conversation about women and public policy for the better.
Welcome to Independent Women's Forum podcast. I'm Inez Stepman, Senior Policy Analyst with IWS, and today we're going to be talking about the dramatic confirmation hearings for Brett Kavanaugh to the Supreme Court with Erin Hawley. Erin is an Associate Professor at Law at the University of Missouri, where she teaches constitutional litigation, tax law, and agricultural law, as well as being a legal fellow here with us at the Independent Women's Forum. Welcome, Erin.
Thanks so much for having me, Inez. I'm glad to be here.
So these Kavanaugh hearings, we had protesters dressed in Handmaid's Tale outfits, white supremacy accusations for White House aides for doing hand symbols. Cory Booker claimed his role as Spartacus. We had arrests, interruptions, even among the legislators themselves, the senators themselves. Is this going to be the new normal going forward for confirmation hearings?
Oh, I sure hope not. I think if we look at past confirmation hearings, while they certainly have been intense and generated a lot of public scrutiny, most of those hearings were still, conducted with decorum by the Senate and the Senate staffers. And I think you have an unusual sort of level of vitriol amongst the senators, something that we haven't seen before. We haven't seen interruptions in the way that we saw this time around. And I hope it's not a new normal. I hope that both parties can kind of step back, and particularly the Democrats for interrupting the chairman and just sort of follow the procedure. And I think if those procedures are followed, then that gives the American public a much better chance to learn about the nominee, to learn about the important issues, to learn about the judicial philosophy of a nominee, rather than just sort of the three-ring circus that you mentioned.
So let's get to some of that substance, since we are not senators at a confirmation hearing, and we have the chance to actually get to some of those important things like judicial philosophy, like some of the key legal issues at heart here. And some of the most heated topics. So the left seems to be absolutely certain that Roe v. Wade will be overturned the moment that Kavanaugh's rear end touches that seat on the high court. Others are pointing out that's probably unlikely. If anything, we're likely to see a narrowing of Doe and Casey, which are other abortion precedents. Could you kind of talk us through that structure, and then where you think it's most likely to go? What do you think Kavanaugh's presence on this court is going to do to that line of cases?
Sure. Well, to begin with, I think we need to talk a bit about sort of the confirmation process itself and how a nominee is sort of obligated to answer questions. So the judicial canons of ethics forbid a nominee from sort of promising how he or she might rule on a particular case. So it's been standard practice, actually, since Justice Ginsburg was nominated in the 1990s, for nominees to sort of step back from answering any particular question as to how they might come out on a case. So sometimes you'll see the media saying, he didn't really answer our questions, or, what about this case, a senator might ask, and how would you rule on that? And it's very appropriate, even incumbent on a nominee, to step back and say, I can tell you how I would approach the issue. I can tell you about my judicial philosophy, but I am obligated not to tell or indicate how I might rule on a future case, because that would compromise my impartiality. So Judge Kavanaugh was entirely correct not to indicate how he might rule on a challenge to the Roe decision. Instead, he indicated, as have prior nominees, how he would approach the decision. And he would approach the decision, he said, by giving the precedent sort of its stare decisis weight. And what that means is that he would recognize that Roe and Casey are decisions of the court, and Casey is sort of a precedent on a precedent. So some people would call that a super precedent. But that doesn't mean it's set in stone. And so as a justice, he would be obligated to look at a challenge and to sort of walk through the stare decisis factors, and to see whether people have relied on that decision, to see whether the decision has proven workable in practice, and then also to consider, whether this decision was correct when it was decided. Something interesting about these constitutional decisions is that the Congress can't change it. So if the Supreme Court got it wrong in 1950, there's a reason that the court might want to correct it. Now, on the other hand, you have sort of the reliance factors and those sorts of things. So in any case, not just Roe, but in any constitutional case, the court's going to think about whether it was right, whether it was wrong. They're going to think about whether people have relied on this decision, and they're going to think about sort of the workability of the precedent.
And do you think we're more likely to see, and I know I'm asking you to predict the future, and that's really difficult, but given Kavanaugh's record, do you think we're likely to see something dramatic, like an overturn of cases, or do you think that we're more likely to see kind of a chipping away, a little bit more narrow reading of, for example, Casey, maybe a little more power for the states to regulate abortion in the second and third trimesters? I mean, do you think this is going to be a dramatic shift, or do you think this is going to be something that is going to be chipped away at perhaps over time, over years, or even a decade?
That's tough to predict, and I think there's sort of two different models that you can look at to see how the court has dealt with past precedents. And a very recent one was in the labor unions case, and the court decided in Abood in the 1970s that public sector unions were okay. And what that means is that you could work for a state government and be required to join the union, or that there could only be one union. So there could be a union in your place of employment, and even if you chose not to join, I should say, you were still required to pay some of the union dues to sort of support collective bargaining activities. So that was in the 1970s in a case called Abood. And just this term in a case called Janus, the Supreme Court went through the stare decisis principles and said, as a matter of First Amendment law, this isn't correct. We can't compel an individual to support speech, to pay for speech with which they disagree. It hasn't proven practical. And the reliance interests, unions may have relied somewhat, but there's still evidence that they can thrive without this mandatory sort of payment of dues issue. So in the Janus case, the court sort of did away with the precedent whole hog, and they said, we're going to overrule Abood. That's no longer the law. On the other hand, if you look at sort of the campaign finance line of cases, you'll see much more incremental moves by the court in looking at, where at prior precedents and then limiting those precedents and doing that typically in sort of incremental ways. So I can't really say, speak to Judge Kavanaugh on his views either on whether he would or would not chip away at or overrule Roe. But I think those are the two sort of frameworks that we might be dealing with.
Sure. The overrule framework or the maybe slower over a series of cases kind of make a anchor precedent less important over time. That's interesting. Anyway, so I guess one more topic that maybe is not quite in the headlines as much, but as a Philip Hamburger fan, and I really encourage all of our listeners to go read Philip Hamburger. He's awesome. I'm going to have to ask this: is do you think this confirmation is or assuming that it happens? How sort of deadly is this for Chevron precedent? And for our listeners, that's where the courts, it's a case where the courts largely gave up judicial review over interpreting the statutes that enable the executive agencies, the alphabet soup agencies, the EPA, various other sort of fourth branch of government executive agencies, and made courts defer to bureaucrats sort of as a matter of course in terms of how they interpret the laws that they are writing regulations under. Scalia famously seemed to be having some doubts after being a strong supporter of Chevron early on, seemed to be having some doubts about Chevron. We know Thomas has deep doubts about Chevron. We know that Gorsuch famously has deep doubts about Chevron and the power of executive agencies. What's Kavanaugh's record like, to the extent that he has one, on deference to executive agencies?
Judge Kavanaugh has been described as being sort of a skeptic of regulation. He comes up from the D.C. Circuit, which is the circuit that gets more of the regulatory sort of cases in any circuit in the country, because, of course, most of the agencies are located there in D.C. So the D.C. Circuit sees a ton of these agency cases, and so Judge Kavanaugh has had a ample opportunity to sort of see the agencies at work. And it's just as you described, under the Chevron precedent, if an agency is implementing a statute that's passed by Congress, then the agency gets to say in its regulation what that statute means. And the court doesn't get to say that that's not the best interpretation. So long as the interpretation is even permissible or makes any sense at all, then the court is required to defer to that. So really sees a lot of power, a lot of actually lawmaking power, as well as interpretive power in the hands of these bureaucratic agencies, rather than with either the elected branches in making the law or with the court in interpreting that law. So Judge Kavanaugh has been described as skeptical, and I think that is fair of his record. He's overturned, I think it's 40 agency decisions. And in his confirmation hearing, he was clear that he's not, he said, a skeptic of regulation in general. However, he said, I'm a skeptic of unauthorized regulation, of illegal regulation, and of regulation that is outside the bounds of what the laws passed by Congress have said. And I think that's a really good place to start. And I think if you look at that last phrase, outside the bounds of what the laws passed by Congress have said, I would guess that Judge Kavanaugh is going to think the judiciary is in the best place to determine what Congress has said, and then weigh the regulation against that court interpretation, which would in effect overrule Chevron.
Another topic that's getting almost as much attention as abortion, and even more attention in the press, obviously, than something like Chevron, thanks to the Mueller investigation, is Kavanaugh's view of executive power. What are some of his views on executive power? And are those unusual views on Article 2, or are they, sort of common among the legal right? I mean, can you just lay that out for us?
Sure. So a number of senators asked questions from Judge Kavanaugh on his views about executive power, and this was sort of a particularly salient topic because he's been involved on that topic on sort of both sides of the aisle. So he was part of Judge Starr's investigation into President Clinton, and sort of in that role, was on the side of the prosecutor and advocated for, prosecutorial access to documents and those sorts of things. And then later served President George Bush as head of the Office of Legal Counsel, and I believe, I think that's correct. And in that role served the president and saw, especially after 9/11, sort of the necessity of executive power in certain circumstances, as he would say, and particularly the president's ability to conduct executive affairs. So I think what the senators were really talking about underneath it all is, what sort of power would an independent counsel have against a sitting president? And Judge Kavanaugh referenced a number of times a law review article that he'd written that talked about what he thought Congress should do. So he thought Congress should exempt a sitting president from subpoena and from trial while in office. Now, it's all a question of timing, as he said. The question is one of when the president might be required to turn over these documents. Is it when he's in office, or is when he is out of office? He did clarify at the hearings that was sort of a congressional proposal, not what he thought the Constitution required. So that is still sort of up in the air. But I think it's fair to say that Judge Kavanaugh has seen the sort of the inner workings of the executive office. He's also seen the inner workings of the judicial office, and he has promised to keep an open mind to sort of these constitutional issues as they unfold.
So I guess now, as we wrap it up, I'd like to get to perhaps the political question. There's been so much sound and fury around this confirmation, but Lindsey Graham is on the record as predicting a comfortable confirmation for Kavanaugh, as many as 55 votes. That would include some Democrats, as well as John Kyle being back in the Senate thanks to the Ducey appointment out in Arizona. Do the protesters and interrupters actually have a chance to stop this confirmation, or is this kind of a done deal, and this is all a dog and pony show for bases back home, for constituencies back home, for video clips for senators to send out to their constituents?
Well, I think if you look at the hearing, it definitely was about video clips. I think there were a number of Democratic presidential potential contenders in 2020 that were definitely looking for the video clip. So that is certainly true. As far as how senators might vote, I think that you will see a fairly party line vote. I think everyone recognizes that this judge is eminently qualified. And then the question is whether you have the potential, Susan Collins, Lisa Murkowski, those sorts of folks, how will they vote? But I would think that you're going to get maybe 55, as many as 57, probably around 55 votes based on the Republican senators as well as Democrats who are in states that tend to be to lean Republican and whose constituents would tend to support a justice who sort of abides by a constitutional vision of the judiciary as a limited one rather than a more robust role for that court.
Great. Thank you for getting us up to speed, Erin. You're listening once again to No Stepman for Independent Women's Forum podcast. I've been chatting with Erin Hawley, who is an associate professor at law at the University of Missouri and a legal fellow with us here at IWF. Thanks for listening.
If you enjoyed listening to this podcast, please give it a thumbs up, share it on social media, or stop by IWF.org for similar content.